Well, good evening, everybody, and thank you very much for joining us for the webinar this evening on representing incapacitous housing clients, a fascinating area, I'm sure you'll agree, although sometimes quite a tricky one. Before I introduce our two speakers, I'd like to give you this important information that the webinar is being recorded. We'll send out the slides and recording link to all who've registered to attend, and it will be made available on our YouTube channel. Please put any questions in the Q&A box, and our speakers will aim to answer your question at the end of the webinar, time permitting, and we aim to finish at 6:30 p.m. So to our speakers, so we have two eminently qualified speakers to guide us through this tricky area. The second speaker I'll introduce first, Tim Baldwin. Tim often acts in cases where the tenant has mental health issues and specialist community care needs, in complex cases involving welfare benefits or concerning social care for adults or children, in tenant claims against local authorities and landlords, and advises on the allocation of social housing. Tim is ranked in the legal directories in a number of areas: social housing, of course, also community care, court of protection, human rights, and administrative law. And he is known, as I'm sure many who are here this evening know him, for his fierce commitment to representing vulnerable, marginalised, and disadvantaged clients. Our first speaker is Angharad Monk, and Angharad is a housing law specialist. She regularly conducts work across all areas of housing law, including homelessness, allocations, possession, disrepair, in addition to accommodation-related aspects of community care law. Angharad's comprehensive knowledge of housing law enables her to provide practical advice and creative solutions in complex cases. And Angharad is ranked for social housing as a Tier 1 rising star in the Legal 500 2024. So without more ado, I will ask Angharad to start. Thank you.
So I'm going to be talking about litigation capacity and practice and procedure issues. And then what Tim is going to look at is some practice context specific applications of these issues and where they tend to come up most in our day-to-day housing practice. It's a huge topic, so I'm going to be as quick as I possibly can over some of the parts of this that I think we're probably more familiar with. First slide, I'm just highlighting a number of really useful sources and guidance when we're dealing with issues around capacity. Obviously, we've got the Mental Capacity Act, which is where we go to for our definitions of mental capacity and lack thereof, and for the statutory approach to its assessment. And we're going to look a little bit more at that in a moment. Of course, Civil Procedure Rules Part 21, which is, as we're in the civil courts, that's where we go to for procedure in respect of protected parties, which, as I'm sure you're all aware, includes those that don't have litigation capacity. Then the Law Society and the Bar Council both have really helpful guidance documents in relation to working with clients without capacity. Solicitors in the audience might find that the Law Society's one is more geared towards your practice, and the Bar Council one is obviously aimed towards barristers, but actually there's helpful things in there for both sides. Another really helpful tool, and I strongly recommend looking at this, is the Equal Treatment Bench book, which is obviously aimed at the judiciary. And it's got a whole chapter on issues to do with approaches towards capacity, and there'll be a couple of times in this presentation that I'm citing from that. You'll find that because it obviously is aimed at the bench, it can be really, really helpful if you're facing a particularly difficult approach. So it's good to have a look in there and see what judges are being directed to do in terms of dealing with capacity issues. To go quite quickly over what I think is probably familiar to most people is what the meaning of litigation capacity is. And we're looking at Section 2 of the Mental Capacity Act here. And a person lacks capacity in relation to a matter if at a material time he is unable to make a decision for himself in relation to a matter because of an impairment of or disturbance in the functioning of the mind or brain. And it doesn't matter whether that impairment or disturbance is permanent or temporary. So the things to note here is that obviously capacity is assessed on a decision-specific basis. So we need to look at the specifics of what decisions need to be made. It can fluctuate and change over time. And also the causes can be quite broad ranging. So it's not limited to more sort of confined definitions of, for instance, disability or mental illness. Then in terms of how to actually assess inability to make decisions, we look to Section 3 of the Mental Capacity Act, and we're looking essentially, this is a functional test at a person's ability in relation to a specific decision, whether that person is able to understand the information relevant to the decision, whether he can retain that information, whether he can use or weigh that information as part of the process of making a decision, and then fourthly, whether he can communicate that decision. And I should say that the backdrop to all of any assessment of capacity is that the first principle in Section 1 of the Mental Capacity Act 2005 is that the presumption of capacity. So we will assume that a person has capacity until it's established that that person does not. I'm not going to read at length, but the leading case in terms of capacity in the context of litigation is Masterman, Lister and Britton and Company. And essentially that case deals with the context of legal proceedings and what it means for a person to be able to make the relevant decisions. And I'm not going to read out at length because I think it's probably quite familiar, but you'll have the slides after this talk in any event. So then when do we have situations where doubts as to capacity arise? Most of the time, it's going to be the solicitor that will identify these issues if it's not already been identified before the person gets legal representation. And then what they need to do is essentially start taking steps as soon as there's any kind of concern from their own attempt at capacity assessment to seek a medical opinion on that, because really it shouldn't be the legal representatives that are making the final capacity assessment. We're not qualified to do that. It is also possible for other parties to bring the issue before the court. It can be an opponent, particularly, but that would mostly be relevant in circumstances where the potential protected party is a litigant in person, and the court has jurisdiction and must, in fact, investigate if it has concerns itself as well. So then what is supposed to happen if somebody does raise the spectre of doubts as to litigation capacity? This is the point where we look to what is the consequence of a lack of capacity in terms of the CPR, and that's contained in Rule 21.3. Essentially, no step should be taken in proceedings until that person has a litigation friend or without permission of the court. And any step that has been taken without a litigation friend, if that person has lacked capacity at the time, is of no effect until otherwise ordered. The difficulty with Part 21 is that it essentially already assumes that the court has made a determination that a person lacks capacity, because it tells you what to do with a protected party. At the moment, there are no provisions in the CPR that deal with how to essentially deal with a question, with a doubt as to capacity, which is a rather unhelpful lacuna in the procedure at present. There is some helpful stuff in the Equal Treatment Bench book, and you'll see I've quoted there paragraph 42 that says that the court should always investigate the question of capacity at any stage of the proceedings when there is reason to suspect that it may be absent. And obviously I'm highlighting that the reason that's important is because otherwise steps taken may be of no effect. And then it's emphasized again in the following paragraph that this is despite the presumption of capacity. So you'll see the presumption of capacity is important and ensures proper respect for personal autonomy, and courts should not allow arguments about litigation capacity to be used unscrupulously. However, and it's important, an important caveat is that when there is good reason for cause for concern and legitimate doubt as to capacity to litigate, the presumption should not be used to avoid taking responsibility for assessing and determining capacity. I found this is quite a helpful passage to cite at a judge that might be threatening to plough ahead, despite the fact that one of the legal representatives has raised issues as to capacity. Clearly, they're not supposed to do that. There's also a very helpful judgment that I've got a number of quite lengthy quotes in this presentation from, which is of Her Honour Judge Lazarus in the Family Court in the case of Zed and Kent County Council. And it's obviously, she basically in that case goes into a lot of detail, having considered a lot of courts of appeal authority in respect to these issues of capacity and how it should be assessed. And she gives a very detailed judgment that bears reading if you're in some doubt as to how you should approach issues as to doubtful capacity. And she said there that the presumption of capacity is emphatically not there to obviate an examination of the issue. It can't have been Parliament's intention to place a vulnerable person in danger of their lack of capacity being overlooked at the expense of their rights by a slack reliance on this presumption. Unfortunately, it does still happen. So it's worth having those authorities and the equal treatment bench book up your sleeve in case if you're heading to court, having just discovered that you've got concerns as to your client's capacity. So then the view is that basically any legal representative, absent some kind of exceptional circumstances, any legal representative's view that they've got concerns as to their client's capacity really ought to be enough. And the court really, at the first instance, which is just to, adjourn it off and get more expert evidence, basically, usually in the first instance, shouldn't be really pushing people for more information on that. Unfortunately, it does happen that the judge will ask you to sort of justify why you've got concerns as to client's capacity. And I would say you need to be really careful with this because essentially what the judge is asking you to do is likely to be a breach of confidence to your client because essentially they're asking you to give information about your private conference with your client and the reasons that you've got doubts as to their capacity. You could potentially ask to have that discussion ex parte if they really want to have more information, or you can just try and give information in a kind of the vaguest, least specific way possible, but you need to be really careful. But yes, what should then happen is that basically any matter that's already rolling is adjourned for capacity evidence to be obtained. It's really helpful if you've already got dates. It tends to put the judge's mind at rest that things are not just going to be kicked off into the long grass indefinitely. You've got an assessment that can go ahead on such and such a date, and that should enable the matter to be relisted as soon as possible. There should be no other orders made, not even any kind of costs orders or directions. Really, it just needs to be focused on resolving the issue of capacity first before anything else is determined. So then in terms of getting evidence, usually you're going to want a psychiatrist if it's a mental illness issue. Sometimes if there's a learning disability, a psychologist can be more appropriate, but usually one of those two would be preferable. In terms of what they need to do, at the very minimum, they're going to need to complete the certificate as to capacity to conduct proceedings form, which hopefully most of you be familiar with. You can find it available online. And that form basically takes them through the test, and it includes boxes for the relevant parts of the test so that to invite them to give appropriate reasons for any finding that the person lacks capacity. You may want to also ask them to do a more detailed report. You're going to want to be careful about what kind of information you put in your letter of instruction. There can be cases, in my view, where it is appropriate, not always, but in some cases it can be appropriate to explain the reasons that the legal representative has concerns as to capacity, because it might be that a proper assessment can't be conducted without that information. But again, you need to be sort of careful about limiting that to what is required, because it's entirely possible that all of these documents will ultimately be before the court and also possibly before your opponent. So I think at that early stage, you're also going to have one eye to the future progression of the case after the issue of litigation capacity has been dealt with. And it might well be that because of your client's mental health presentation or disability, that you're considering Equality Act defences, all kinds of issues. And it might be that full well that if you're going to proceed with the case, that you're going to need evidence from a psychiatrist in a number of regards. My view is that it makes sense to try and get that all at once if it's possible. But what you should do is to try and make sure that all of those additional points are essentially hived off and can be separated from the part of the report that relates strictly to litigation capacity. And I'll explain the reason for that when we get to a little bit further along. So yes, then what do you want to do with it? So as soon as you've got the certificate as to capacity to conduct proceedings, you'll need to provide that to the court if the client, this is all assuming obviously that the client has been found to lack capacity. Then If there's an expert report, I think it's usually appropriate to file that with the court as well if it has evidence that's relevant to the assessment of capacity, litigation capacity, that is. There is a bit of a tricky issue as to whether you should actually serve the certificate and the report. And there is actually, I have to say, some disagreement between practitioners as to what the appropriate thing is to do here. We're going to have a little bit more look at a case called Folks and Fazy in the Court of Appeal, which looks a little bit at the degree to which litigation capacity is an inter partes issue. And what my view is essentially is that this really, in the vast majority of cases, is not going to be an inter partes issue. And as such, the evidence that goes directly to the litigation capacity isn't relevant for the other side. But what is particularly important to bear in mind is that if your client does lack capacity and you haven't yet got a litigation friend who's been appointed, essentially you're without instructions, and it's my view that it's not appropriate for you to serve confidential medical information on the other side until you, at the very least, have a litigation friend that can tell you that that's what they want you to do. And I think that's consistent with what the Law Society says, which is that essentially, as soon as a person lacks capacity, the retainer is lost until such time as there can be somebody put in place to validly give instructions. This can be really uncomfortable. So opponents will often demand to see it, in my experience, and will kick up a big fuss about the fact that they've been, they're having a medical report hidden from them, and judges even on occasion might order it to be disclosed. There's no easy answer as to how to deal with that situation, and I think it's a bit of a judgment call. But if you are serving it before the appointment of a litigation friend, whether that's the certificate or whether it's the expert report itself, you want to limit that as much as possible to the matters that are relevant to litigation capacity rather than any other element of it that you might have got. So there might be an extensive background, which might have a whole load of information that's possibly prejudicial to your client. And you don't want that to be provided unless it really has to be. Another tricky situation is where you can't get medical evidence. And often that will be because the client doesn't actually accept that they've got a capacity issue and they don't see why they should need to be assessed, and they're not willing to comply. Basically, the courts have looked at this issue a few times, and they're going to be very, very reluctant, I think, is the headline, to make a determination of capacity without medical evidence. However, it might be that there is literally no other option than the court having to make that determination without the medical evidence that they would like to have. And this was, I've cited a number of Court of Appeal and High Court authorities there, but a really helpful case on this is the Zed and Kent case with Her Honour Judge Lazarus, and I've cited extensively from that here. But essentially what she says is that there's going to be situations where, even though it's obviously much, much better if you do have an expert or medical assessment, that you're going to have to go ahead and determine it. The court is going to have to do so. And then she provides some guidance as to how that could be done. So you'll see here, she says that a determination could be based on a careful review of the other material that may be available, such as a report from a clinician who knows the party's condition well enough to report without interviewing, medical records, accounts of family members, accounts of social work or other agency workers who may be supporting the parent. Should be noted that this is in the context of a consideration of children in the family court. So obviously the parent element of that may not be relevant, but you might have family members that can give evidence. One thing that you can do is ask the court to determine the issue in an ex parte hearing, emphasising the Folks and Fazy case essentially says that this is usually not going to be an inter partes issue, and that would enable the court to possibly even speak to the client, and the judge could possibly even speak to the client to do their own capacity assessment, as well as to have a more open conversation with the legal representatives, so that the judge can test capacity themselves. They're going to be enormously reluctant to do this, but there may be situations where you're just not getting anywhere, and essentially the case is being adjourned again and again and again. and there isn't really no other option. So the Equal Treatment Bench Book says, in relation to this issue, that where there's practical issues in obtaining medical evidence, the official solicitor may be contacted, although doing so should be a measure of last resort. So I'm a little bit unsure what the purpose would be of, I mean, there might be situations where that could help, but it's not entirely clear to me if you've got somebody who doesn't accept that they've got a capacity issue and they're not willing to be assessed by anybody, basically, that getting the official solicitor involved is actually going to assist with that. But, you know, I also I've never actually done this myself or reached this point, so I'm not sure how the official solicitor would respond to that kind of request. Perhaps there might be someone
just letting you know, a couple of minutes to go. Yep.
Oh, thanks very much, Bethan.
Okay.
I will hurry up. But yes, I was just saying, so perhaps if there's anyone else here tonight that has tried to do that, and I'm not talking about appointing the official solicitor here as a litigation friend. This, I think, what it seems to be suggested is that this is getting the official solicitor on board before there's been a determination of capacity to get them to assist in some regard with the assessment. So then, yes, Folks and Fazy, this is a case which addresses the issue of to what degree does the other side have a right to be involved in and contest issues around the parties, the potential protected party's capacity. Basically, I'm not gonna go through all of this because I don't have enough time to do that with you. But essentially, the court held that in that case, what had happened is the other side had objected to an application that had been made to appoint a litigation friend with expert medical evidence, and the district judge had sent it off for essentially to be determined at a kind of preliminary hearing that I think, I can't remember the listing, but possibly even a day long or 2 days, where there was going to be sort of both sides having expert evidence on the point, and it was going to be put as a contested issue. And that was then appealed, and the appeal was successful. And the court essentially found that the other side in that case had not really demonstrated that they had any kind of legitimate interest in the process of appointing a litigation friend and the issues of capacity, and that actually they should really not have been involved at all. There's a really helpful summary here that I've borrowed actually from one of Bethan's former webinars on this topic, but I think a really helpful paragraph from that judgment is paragraph 19 here, where you'll see that the court's described, it says that I would not wish to describe the opposition to the application, that is, as an abusive process of the court, but in my judgment, it is an intermeddling for no sound reason, which the judge on the evidence available ought not to have tolerated. So in my view, what that's saying is that although there might be some situations where it could be appropriate, generally this is not going to be an inter-parties issue. And if there isn't any particular reason, particular relevance to the other side, their involvement would be intermeddling and shouldn't be allowed. So we can say that when we have situations where opponents are sort of demanding to make submissions on medical evidence and the like, which does happen quite a lot. In terms of getting a litigation friend, first step should always be to try and find somebody who would be appropriate, so a friend or family member. You're probably all aware that they need to not have a conflict of interest with the protected party, and they need to be able to make decisions in a fair and competent way. When you're approaching someone, it's really important to advise them carefully about what's going to be required of them and the nature of the case, so that we don't end up sort of getting into a situation later where they're feeling like they're not able to fulfill the role. In terms of cost liability, essentially it's not entirely impossible for litigation friends to have cost liability in their personally. And that even applies, unfortunately, to defendants' litigation friends, although it's not usually going to be the approach. And there's the case that I've cited there of Glover and Barker, where it's really limited it to situations where there's bad faith or other sort of impropriety. they need to be advised of that, obviously. And if they're going to sign, if somebody that's proposing to act as a claimant's litigation friend, then they will actually have to sign an undertaking in respect of liability for costs. One way around this that I've used in the past is particularly if you've got a local authority or a housing association opponent, is to just simply get them to undertake that they're not going to seek costs against the litigation friend in their personal capacity. Often it's going to be in their interests, because if they don't get a litigation friend, they'll be waiting a long time to get the official solicitor involved, and they probably want things to progress as well. If there isn't anybody suitable, then it's going to be the official solicitor. Everybody knows it takes a long time to get the official solicitor involved. Usually the courts are quite understanding about the time that it's taken, as long as you can show that you've actually taken all the steps that you can to make the arrangements.
Jodie, are you nearly there, Angharad?
I am nearly there. Bear with me. I can
Brilliant.
probably skim over the rest. I've just provided you there with the provisions that are relevant to how a litigation friend gets appointed. I think probably most people are aware of the process for that, with filing of a certificate of suitability. But if you're not, that's there in the presentation that you'll be given after. My final slide is about removing the litigation friend, and there is a process to do that, basically, where the court can do so on application or of its own initiative. And if anyone wants to read a rather alarming judgment, then I've cited the recent case of Major and Kirishana, in which His Honour Judge Luber was found to have acted wrongly in refusing a litigation friend's application to cease to act as litigation friend. But I will leave it there and hand over to Tim.
Thank you very much, Angharad. That was amazingly comprehensive and clear and really extremely useful. I'm sorry to have had to rush you. Every word was a gem. Thank you. Tim, over to you.
So the issue here is that getting a litigation friend in place is your very first step, and that can be quite arduous in itself. And so what we're going to focus on really is looking at capacity in a broader sense, because issues about capacity can relate to a load of other matters that can come up within possession proceedings. And just appointing a litigation friend alone who deals with matters of litigation, that specific issue, may not be the only matter of capacity that you have to consider when representing an incapacitous client. And one of the first things that you probably be concerned about is that in possession proceedings, capacity and risk of findings of intentional homelessness, which we'll turn to in a little bit. And what we're going to look at is specifically capacity and the pre-action protocol. We're not going to really have time to cover rent possession cases, but hopefully the issues that I'll identify within antisocial behaviour cases and injunctions will inform your approach to dealing with rent possession cases. The difficulty around hoarding, and there's a particular case that I've cited there that is worth looking at in respect of the interplay between possession cases and the Court of Protection. And we'll touch on the little tricky thing about succession. What if you are involved in a succession case involving clients who lack capacity in some form other than just litigation capacity, and how can a Court of Protection help you? And just at the end, to identify how you should link cases where you have a lack of capacity with cases that raise discrimination defences and counterclaim. So the issue of mental capacity, tenancy and licence issue. And the key thing to always remember is that a person who lacks mental capacity cannot enter into a tenancy agreement, assign or vary it, or end it. And particularly when the landlord has knowledge of that issue, the landlord cannot enter into a tenancy agreement with somebody who lacks capacity. But often what you find is the tenant is a person who becomes lacking capacity during the duration of their tenancy in terms of their ability to manage and comply with the terms of it. And it's all bound up in their ability to contract and comply with the terms of a tenancy agreement. So if somebody lacks capacity and you're within litigation, you might have to think about seeking other sorts of remedies and litigation. And that could be looking at getting court-appointed deputies to allow somebody to enter into a new tenancy, if that is a way forward of resolving the possession dispute, or terminating the tenancy, or being able to have a role in managing the rent payments and housing benefit. Also, you have to look to see if there is someone knocking around with the lasting powers of attorney, which is a similar power to that of a deputy. And it may be that you just have to seek an order from the Court of Protection. The Court of Protection can do this, the county court can't, to make provision to enter, assign, or vary or end a tenancy by way of a Court of Protection order. And this goes beyond the limitations of a litigation friend within Part 21 in possession matters. Applications for welfare benefits, you have to think about, does my client need an appointee? Is it something that is dealt with as a necessity under Section 7 in the MCA? And a case to always have in the back of your mind is the Whitehaven District Council case. And this was a benefits case, but it was a case where the tribunal held that a purported tenancy agreement with someone who lacked capacity was actually a nullity. It was a nullity, as the tenant was so severely disabled as to not be capable of indicating any assent to that tenancy. But the tribunal went on to hold that the tenant was entitled to housing benefit because the supply of accommodation had been a necessity. So in all these situations where somebody lacks capacity, the provision of benefits and continuation of rent is always identified as being a necessity, because they need a supply of some accommodation. So possession, capacity, intentional homelessness, this is always really a major concern when you're dealing with somebody who lacks capacity in terms of possession proceedings, because often it's some aspect of their incapacity that leads to allegations of breach of the tenancy agreement and leads to possession proceedings. So the instant thing that often comes into people's minds is, well, if we end a tenancy, or if there's a problem about this tenancy, will that lead to a finding if we have to look for other housing through, say, the homelessness route? Would that lead to a finding of intentional homelessness? And the Code of Guidance is kind of peculiar because it doesn't necessarily match what is said within sections 1 to 4 of the Mental Capacity Act. And what it says here, it puts the onus on a local authority, where it says a housing authority has reason to believe the applicant may be incapable of managing their affairs. So that's very similar to the Masterman-Lister test, but it's a low threshold. They just have some reason to believe, not that they lack capacity, some reason to believe that they're incapable of managing their affairs. And that's by reason of age, mental illness, or disability. And the act or omission was a result of limited mental capacity. Well, limited mental capacity doesn't really fit as well with the definition of mental capacity within the Mental Capacity Act. Either you lack it or you don't. There's no definition of really what is limited mental capacity, but there's temporary aberrations caused by mental illness. So I would say, if you have somebody who lacks mental capacity within possession proceedings, not just solely in relation to litigation capacity, but it's not really an issue when you're seeking further accommodation through Part 7, because it can't really be held against them if the Code of Guidance is properly applied. So, naturally, there are often concerns around loss of accommodation due to rent arrears, antisocial behaviour, and hoarding. And often the instinct of a housing lawyer is to say, well, we must hang on to this tenancy at all costs. That might not be the best way of doing it if the tenancy is no longer viable. And one of the key developments really from the past was that someone who lacks mental capacity cannot make an application for homelessness assistance because they're unable to understand the terms of their tenancy agreement. That remains good law, even though the case is somewhat old and is pre-MCA. And it was held to be good law in the case of WB. And what it did was identify that even if you lack capacity, you can get somebody to do the application on your behalf. You could get a deputy appointed. So there's a way round the whole issue of getting back into some form of accommodation when the actual tenancy is not viable. And the other thing that's of note is that capacity issues in the pre-action protocol, not just rent. It's one of the things that's often missed, and that is that local authority officers are professionals for the purposes of the safeguarding provisions within the Mental Capacity Act. And it talks about it talks about in particular 42(4)(c), where capacity is a safeguarding issue. So there, that should then engage a local authority officer to deal with issues of capacity at the front. Because if one looks at the pre-action protocol, particularly paragraph 1.5, there are issues about ability to understand information and reading, but also B, if a landlord is aware that the tenant is particularly vulnerable, the landlord should consider at an early stage, and that should even be prior to issuing a notice to quit or a notice seeking possession, whether or not the tenant has the mental capacity to defend possession proceedings and the extent to which CPR 21 applies. So then, at an early stage, if they are going to go to court, it should be the local authority to make the application. And also it's linked to issues under the Equality Act and whether there's a need for community care assessment. There's not the same obligations on private landlords, but private landlords, the Equality Act provisions may apply to a case. That doesn't exclude them, particularly section 35 doesn't exclude them. And part 21 of the CPR also applies in respect of private rented tenancies. So we've got an outline here of, again, of the possession basics, and you've already had that very excellent outline by Angharad. But really, one of the things always to keep in mind is that to discharge the duty requires litigation friend to acquaint themselves with the nature of the action and under proper legal advice, take all due steps to further the interest of the child of the protected party. So it's these cases that are key there. And also another case that is useful to look at and cite is this case here. Again, it's within family proceedings, but it's by Mr. Justice Mostyn. And Mr. Justice Mostyn gives a very thorough review and understanding of the importance of getting the appointment of a litigation friend right. And often some cases have taken too much of a superficial approach. And also what you have to think about is the distinction between children cases under 18 lack capacity to litigate per se, but anyone, and I've just used the phrase adult, anyone over 16 is subject to the Mental Capacity Act. So per se lack capacity to litigate when they become 18 have capacity. When they're adults, in the sense of section of the Mental Capacity Act, there may be a number of children who fall within the ambit of the Mental Capacity Act in possession proceedings. And it's always to have in the back of your mind that CPR 21, if you're going to settle a case, it requires authorization by the court. The court has to scrutinise the settlement of the case. And in damages cases, as well as being a protected party, your client might also fall into a class of what is known as a protected beneficiary, where if damage is awarded to your client, it may require the court to manage that money. And you may again require the appointment of a deputy to deal with this. Antisocial behaviour, first of all, who's causing it? It's a tenant of the family, and often it will concern separate matters that are separate from that of the issue in respect of appointment of a litigation friend. How does a litigation friend deal with that? You will need specialist evidence as to the causes of the behaviour of a mental disorder or disorder of the mind or brain. You have to have in the back of your mind that the legal test for incapacity is a disorder of mind or brain, which is distinct from the legal test under the Mental Health Act. And often within possession proceedings or antisocial behaviour, you'll also have considerations of injunctions. So that's a separate issue as well. So you have the ability to understand the terms of your tenancy agreement and comply with that. Can your client do that? Is there something that is driving them to behave in an antisocial way that is linked to mental capacity issues? And Wookie concerns really, can they understand the terms of the injunction? And in Wookie, although it's a committal case, it can also be used in looking at injunctions, the making of them. And the difference between an injunction, maybe possession proceedings, is that injunctions are an equitable remedy. So the court can look in equity as to whether it is appropriate to make one. It may not be appropriate to make one if someone cannot comply with it because they can't understand it, because they'll be subject to committal proceedings. So it's looking at really compliance with the terms of the tenancy, how to resolve issues. Well, sometimes it doesn't prevent a possession order being made. So you have to also look at capacity, and maybe you have to have assessments under the Care Act, and also use parts of the Care Act that allow you to assess capacity without the incapacitated person's consent. Do you need to make sure that you get interim accommodation elsewhere under the Care Act? Does there need to be consideration of detention under the Mental Health Act? That is always something that has to be factored into a capacity assessment. You may have to make an application to the Court of Protection in parallel proceedings. And the role of the Court of Protection is that it can allow for the court to make orders in respect of moving somebody into specialist accommodation, supported living, or residential care if their best interests and care needs require that. Hoarding, this is a tough one because it's not always easily defined as a mental disorder, and there's a difference of opinion of it. So does the primary thing is, does the person lack capacity on the issue about management of decisions about their items and belongings? So that goes to a very issue-specific matter, and the Supreme Court in A versus JB gives prominence to that. You have to look at it in a very issue-specific way. So the issues that would arise, for example, in a hoarding case, are the main issues here: conduct proceedings, make decisions as to residents, make decisions as to care and support, because often people will try and refuse that, and also manage own property and affairs, manage other persons' property and affairs, particularly if you have a couple or more than one person living together who both may have capacity issues, make decisions regarding their items and belongings, make decisions about the other person's items and belongings. Sometimes they can be moved out of their accommodation. Can they move back into it and stay there with a trial package of care? And whether to appoint a deputy to manage their property and affairs, deal with how they manage things generally.
Just letting you know, 5 minutes, Tim.
Yeah, I've got 4 minutes on my little timer here.
Okay,
so,
lovely.
So I'll be done. So hoarding, is it a mental disorder? There's this whole concept of Diogenes syndrome. And if there's any classicist around you, you remember about Diogenes and his living with dogs over people. And it's quite a complex thing to look at. So it will require very specialist medical evidence to consider, and also within the assessment, it will look at things like the volume of belongings, impact on room use, safe access and use, creation of hazards, safety of the building, and how you go about removing and disposing of hazardous levels of belongings, while remaining sensitive to the impact on the individual. That's always something you have to think about. And you have to get the participation of the person as well in this. If you can get them to buy into it, it also helps. So that often requires a parallel possession claim. It's good if you can get a judge who deals with possession matters and court protection matters to deal with it with the same judge. What happens if the person has capacity? Well, that's a real sticky one, and you can't really force them to do anything. I'm going to touch basically on succession cases, and there was this case whereby mental capacity was not defined as another status within Article 14 because it varied too much. And this was a case where someone went into a care home. The daughter was living at the home with them before they went in, and they died when they were residing in a care home. And the daughter was not allowed to rely on her status, and the mental capacity issue did not assist her. But there's a query that if you had a deputy appointed before the notice or possession proceedings, could they, on P's behalf, assign the tenancy to you or apply to do that? Succession cases, lessons from children. There are two cases here which show that a tenant who died in the first one, Kingston, leaving his 13-year-old granddaughter in occupation. And it was held that a minor was capable of being a person in housing law who could hold an equitable tenancy, including a local authority letting, and could succeed to the deceased tenants, secure tenancy. So it's held on trust by the local authority until they reached a majority. And in the other one of Newham versus Rhea, was held on trust by an executor of an estate through a will. These have conceptual problems, and the question is really whether they can apply to adults. And this really sets out, this article here really sets out the problem. And that is really whether the tenancy actually vests in, and how can it vest in an incapacitated person? How can they, in any way, shape, or form, hold a legal tenancy? How can it legally vest in them? But that might lead to further human rights and discrimination arguments if in possession proceedings it became a dispute. If it works for children, why not for adults? And this just sets out the various jurisdictions of the Court of Protection, which you can look at when you often have to make a parallel application to resolve some of these issues, because the county court can't. And this just sets out as well how you go about making the application. And what I'm going to briefly flag up is never forget that that you should always, in any event, protect your client's position in respect of disability discrimination and defences, counterclaims, and go down that route. So I'm going to stop at this point, and I'm bang on 22 minutes.
Tim, thank you. That was amazingly packed full of useful information, and I'm sure that will be tremendously helpful for busy practitioners who are having to grapple with these issues and need to know the law and need to know it quickly to deal with what are often very pressing situations that we find ourselves in at court or needing to advise urgently. So we have a few minutes left now for some questions, and we do have some questions in the Q&A, and I've just had a quick glance at them, and they are, as expected, quite tricky questions. So here's the first one for Angharad. If your client is certified to lack capacity and the court is ordering the certificate be disclosed before a litigation friend is appointed, can you not argue that such an order is of no effect, because surely there is no defendant stroke litigation friend to comply with it at that point? And that's a question from Martin Wilton. Thank you very much for that question. Thank you.
This is slightly traumatizing for me because I had exactly the same thing happen to me quite recently. So I think, yeah, I mean, I can see the point you're making there, but obviously the court does have a power to validate steps taken. So I think if you try to frame it as a technical argument, you're probably not going to get anywhere. But I think the bigger point is that if the court is ordering you to do that, the court is placing you in direct conflict of interest between your duty of confidentiality with your client and your duty to the court. So actually it puts you in a real pickle. There's no obvious answer to it. I think it's probably, if you're in that situation, one where you probably need to take a break and speak to the ethics helpline, because it is actually a direct conflict of your ethical duties. I know it doesn't really answer the question.
I think one answer, Angharad, is to point to the court that the issue of capacity and determining legal capacity is primarily a matter between the party and the court, and it's for the court to determine.
Yeah. And a reasonable judge would probably accept that submission, but it does happen that judges just lose their patience with capacity issues and make silly orders like directing you to disclose things that are confidential, and it's not an easy one to deal with. I'm not
Thank
sure
you.
if I
well, no, thank you very much. And I would imagine that those of us who, as I'm sure most people here have been practicing in this area, have had to grapple with these sorts of areas where you just hope for a pragmatic approach all round, because there's not always a firm answer that you can fall back on. I'm going to ask you the next one as well, and then I think the next two are for Tim, so I hope that's all right if I just plow on with this next one. So this is from initials AB. If I believe that a client lacks capacity, and as will often be the case, the client does not consent to me disclosing my concerns to the court, are there any alternatives to me withdrawing from the case due to the conflicting duties? The question is particularly focused on duty advice immediately before hearing, where there is very limited time. Another very tricky one, which I know is often comes up in these webinars.
It's so difficult, isn't it? It's so difficult. I mean, again, I think my answer is probably more pragmatic than anything, which is, I mean, I'm sure if this is coming from a duty advisor, that you've got far more practical experience of it than I do. But I just try and frame it to the client in such a way that they understand that it's really most of the time not going to be against their interests, and basically just sort of say to them, I've got this doubt, that means my hands are tied, I can't possibly go ahead today without us looking into it a bit more. What will happen is that the court will hear that, and then we'll just be put off to another day after somebody has given you an assessment. But obviously sometimes that just won't work, and the reality is you can't just sort of put it aside. You can't just ignore the concerns that you've got. If you've got those concerns, unfortunately, it's your duty to raise that. So yeah, it's a very uncomfortable one.
Thank you very much. Tim, if an expert needs to be appointed to assess capacity, how can they be funded if the client is not legally aidable, or if you can't get the information necessary to consider legal aid? Can the judge order an expert be appointed at public expense? And this is from AB as well.
That's a difficult one. The way to do it would be to have the other party undertake to meet the costs of that a report. I don't think the judge has the power to make an order to direct that it be funded out of public funds. I don't know how that can really happen within the civil jurisdiction. But what can be done is often in certain cases like this, where particularly where there's delays in getting legal aid, that in order for the case to progress, if there is an issue about capacity that remains unresolved, then you can seek an undertaking from the other party to effectively indemnify that cost. That is what I've done in the past in a similar situation. Get the other party to pay for it, because particularly if it's a public body, that it's in their interest to actually progress the case. So you can do it that way.
Thank you. Thank you, Tim. Tim, I'm going to ask you another one, which I think is quite squarely within your area. How do you challenge a local authority refusal of homelessness application as no capacity to make a homelessness application, accept an allocation, or manage a tenancy? The decision must be made by the officer, citing the case of ex parte Begum and WB against W District Council. So I think the gist of this is then, how do you challenge a local authority refusing to accept homelessness application on grounds of alleging or asserting that the person lacks capacity to make that application?
First, it is an issue as to whether or not they do have that capacity or not. That the first issue can be dealt with within court protection proceedings under Section 50, making application under Section 52 of the Mental Capacity Act, and you can make an urgent application. And if you look at what I think there's an order at the end of WB that talks about how you deal with that in the interim, in terms of interim provision. I can't remember precisely, but you can get the court to authorise that the local authority should provide at least interim accommodation, maybe under the Care Act or so on and so forth, or the court to make an interim order. But the reality is, what you need is to take it to the Court of Protection, one, to determine the issue of capacity. Secondly, if capacity goes against you, then the court can appoint on application a deputy, and the deputy can make the application on behalf of the incapacitated person. And I think there's a mechanism within WB that tells you how to do that, and there's an order at the end of it that deals with the issue in the interim. Because all you need to get it before the Court of Protection is some reason to believe, and the court can make interim orders under Section 48. For example, it would be in P's best interest that they be provided with accommodation, something like that. I can't remember what the exact terms of the order are, but there are mechanisms within the Court of Protection to deal with.
Tim, thank you very much. Now, I'm not going to be able to cover absolutely everybody's questions, but I would like to include at this point, if I may, some very helpful observations from Susan Hardy from the official solicitor, who has said, one, on the issue of capacity reports and no funding, the Civil Justice Council Working Group on Mental Capacity will be sending out a consultation, which includes this issue, in the next few weeks. So that's very helpful. Thank you very much. And also from Susan, we have point of information that the certificate of capacity to conduct proceedings is the official solicitor certificate. I think the CPR has recently been updated to say the evidence of lack of capacity has to be filed when the N235 certificate of suitability is filed, although that does not answer the question of what you do before there is a litigation friend. On delay in the OS, official solicitor agreeing to act, there's a question in the chat about asking about delay of the official solicitor coming on board. This will be speeded up if, when referring the matter to the official solicitor's e-referral form can be completed in as much detail as possible. So thank you very much for that helpful tip. And then finally, we're working hard to reduce delay, but we need as much information as to whether the whether the OS's criteria to act is met as possible. So thank you very much for those observations. Now, I think if I just take one final question here, and I think just read this one out from Fiona McGilvery. A question about compensation for a client without capacity. I have a case where there is compensation of £15,000 in court funds. The official solicitor has instructed us to ask the local authority to make an application to the Court of Protection regarding administering the money. But how do we proceed when the local authority won't do this? This is a sticking point in a lot of cases. I think that's one for you, Tim, if that's all right with you.
Is it, I mean, when you say to proceed, is it to appoint a deputy or somebody like that?
That would be my understanding of what it's meaning. Yeah.
So what you're looking at is someone who is going to act as the applicant for the making of the deputyship order. Is that right?
I mean, I think that must be the gist of it. So you've got the compensation payment, and obviously that needs to be appropriately administered. It requires an application to the Court of Protection, and it is really a question which comes up a lot in lots of different areas: is who's going to make the application? Because obviously, work and resources, and if there isn't a public body there that is eager to do it and's got it on their list, then it doesn't happen. I mean, so how do you get that onto somebody's list of something they're going to do?
Is it just to make the application or act as a deputy? Because if it's just the application, then pressure can be put on local authorities to do it. If they don't, then you're going to have to find somebody who could step in just to make the application. It may be that you can approach somebody who's a professional deputy, court appointed, on the list of court appointed deputies who might be willing to make that application. But you need to find somebody. I know the official solicitor, for example, doesn't become involved in those types of cases, but it may be that you can find somebody who is willing at least to act as an interim deputy in order just to make the application, with a view to make the application that it seeks the court to then appoint at least an interim court appointed deputy and then to take over. It's really just a matter of finding somebody who is willing and able to make that application.
Yes, absolutely. And the bottom line, I think, as you're suggesting, would be that the local authority would be required ultimately to do it. Where a person lacks capacity, they're going to trigger local authority duties in one way or another. If it's not under the Care Act, then it's going to be some sort of bottom line Article 8 safeguarding provision, or simply
it may prompt a judicial review as well. You know, is this unreasonable behaviour, particularly if I don't know why somebody's got these damages, but if it's there as a result of the local authority's default, then I don't see why you couldn't, in theory, at least threaten judicial review of their failure to make the application. I mean, it's probably worth looking at all of the Neary case, the Neary cases, and making applications there, and local authorities' role.
Thank you. Well, thank you very much. And thank you very much for these questions. We haven't had time for every single one of them, unfortunately. And I'm sorry about that, but they've been really great questions and really great answers. And finally, we would welcome your feedback. And when you leave the session, a box should pop up, which gives you the opportunity to leave feedback. So please do so if you can. And thank you very much for joining us. And thank you very much to our speakers. And I hope you enjoy the rest of your evening.